and Murugara George. For the Speaker of the National Assembly is Benson Milimo and Josephat Withdrawn. For the Senate, Professor Ojienda Tom, Senior Counsel, Moni Mukele Edwin, and Senator Hilary Sigay. For the Speaker of the Senate is Mercy Tanji and Peter Wanyama. For His Excellency the President, Adrian Kamoto. For Professor Kindiki, he's an interesting. Mudoni Piankolu, Moses Kipkogei, and Ken Melo.
Your Lordships and Your Lordship, my name is Kipe Mongai, appearing in this matter with the following.
Just a minute. Yes, yes.
My Lord, in this matter, I appear with Senator Daniel Manzo.
Your name, please.
My name is Kipe Mongai. I thought I said it to you. Kipe Mongai.
Yes.
I appear in this matter, my Lord, with Senator Daniel Manzo, Mr. Ndegwa Njiro, Honorable Jerry Maina, Mr. George Santimpa, Mr. Andrew.
Mr. Kibe, we are recording the Quran, please. Yes. Can you start from Dan Manzo?
Dan Manzo, Mr. Ndegwa Njiro, Senator Honorable Jerry Maina, Mr. George Sankipa, Mr. Andrew Muge, Mr. Kirago Aduta, and Mr. Kenneth Matiba, who is on the way, and Professor Ogada.
Professor Ogada, present.
And Kenneth Matiba is on the way. My Lord, we appear in this matter that continues to be referred as Kerugoya, petition number A015 of 2024, that appeared to have been filed on the same day.
So you appear for which party?
We appear for the petitioners in that.
This appear just for Kuyoni. They appear for Parliament. Which one is this? Kuyoni.
In 565. Which one is it? Which petition is
This
it?
one. This is 5.
This one. This one is just this one.
Speaker of the National Assembly.
Which one are we talking about?
Yeah.
Yes. Speaker of the National
Yes.
Assembly.
Yes.
Was
Your Ladyship, this petition E015/2024, the Lugoya file. Again, we appear for the first interested party, that is the Deputy President of the Republic of Kenya, in this E015. Because again, let the record capture and show that council appearing for the first interested party appear under protest. Council as follows: Paul Mwite, Tom Acharia, Elisha Ogoya, Faye Waigwa, Victor Swanya, George Wadati, and John.
Can we have that again?
Yes, I'm sorry. From what point, my lord?
From yourself.
Paul Mwite, Tom Macharia, Elisha Ongoya, Faye Waigwa, Victor Soanya Ogeto, George Wadati, and John Jomo. At the appropriate time, we will be going into the grounds and basis for appearing under protest. I thank you.
My Lord, before there were also certain clarifications that I would like to be given before the hearing for today. Direction for today's hearing can be given. My Lord.
My Lord, before Mr. Kibe moves on that file, are there other files, especially file number petition E572, 2024? Is it before the bench?
We'll take forums on the files which are brought out.
My lords, may you kindly equally confirm whether E509, which was consolidated with E522, is before the bench. One reason, Your Lordship, is that the bench was specifically constituted for that purpose.
Petition E13 of 2024, High Court of Kerugoya, Thomas Kimozo Maingi, petitioner versus Deputy President of Kenya, respondent, and Honorable AG.
My Lord, that matter is not before the court.
Your Lordship has been called. It is the court that you know whether it is before you know the Attorney General.
We had a
And we also want to know whether it is before this court.
very sure.
Yes, yeah.
Can you open CTS? Can you access CTS?
Open it.
We give directions on the CTS. That is what it is.
Yes, exactly what it is.
My Lord,
So,
my ladies, kindly, with your kind permission,
yes.
I would also want to seek clarification for my own petition which I have filed, petition number E567. I had information that that file was also coming up before you this morning, and I would like to know whether the same is before you, and if so, whether we can also proceed with it.
When was it filed and where?
It was filed on the 18th of October 2024, and it came up before Honorable Justice Mamuye, who gave direction that it will come up actually tomorrow, and I believe that is part of the reasons why there is protest in this matter. And then I was informed that it's coming up today, so I also need clarification.
Please, the court.
Yes.
My name is Dr. Eboso. I'm a petitioner in E541 of 2024. A petition that was filed on 8th of October, and a petition in which we got directions on 16th of October, directing that it be brought before the Chief Justice for this bench. It raises the same issues as the issues that were consolidated, and I'm appearing in person with Ms. Ivy Mwangi, the second petitioner, and we were seeking clarification with regard to directions on that file, because as we can see, there are files that were filed on 17th of October, and which directions were given, and the bench was considered. So we expected that the matter would be mentioned together with this one. Thank you.
Lord, with utmost respect, this honorable court is a court of record. And the record is very, very important. My Lord, your leadership, we heard the court assistant call out petition E13 of 2024, which you mentioned the 134. That is the file that was done. And in order for the record of this code to be systematically accurate and easy to follow, may I with respect ask that we get clarity on this file that was called out E13/24 of the lawyer before we go to the other matters. And perhaps it is for this honorable court to clarify which files, one by one, are before this honorable court this morning.
Senior Counsel Paul Mute, we are giving you time to talk. You see, everybody wants to talk. There will be a time for us also to talk. So I've heard you.
Thank you.
For this morning, for the purposes of hearing this morning, the applications which are before the court are application number E0113, which was consolidated in Kerugoya before it arrived here with E0114. 0114. Then we have application number E0115, also from Kerugoya. That is application before this court. And then we give direction on those applications. And then E565. Those are the three matters which are before this court and in which the Honorable the Chief Justice has constituted this bench for hearing and determination. If you, there are articles of constitution of this bench in the record. So the three matters before the court are E565, E015, E0113, and E014. Those are the files and petitions, applications before this court. And those are the applications on which this bench has given directions pursuant to this bench being duly constituted. So any other applications which we are talking about, we have not cited them. Maybe they are yet to reach us, but for the purposes of today's hearing, we have these three petitions or applications.
Your Lordship, we well guided. And perhaps also to state for record that we also appear in E015 in protest. But further that, Your Lordship, kindly confirm that the number that is now registered in the matter that came from Uruguay is E015. And that is important, Your Lordship, because of the purposes of administrative transfers of files. Because what was at Uruguay, Your Lordship, was E015. Does it therefore mean that that file has not yet been integrated into the Nairobi files? And if so, then how do we appear to proceed before you, and how was the matter that we can raise the issues? Just confirm on the question of the integration of that file in the Nairobi files. Because the last file that we have should be 565 as at Friday. Are we dealing with the matter in Uruguay or in Nairobi?
Yes. Let me deal with that. My Lord, for the purpose of E572 of 2024.
That file is not before us.
That's all I'm only saying. I have had the directions of the bench. The file is not before you. But I have instructions for the purpose of the world to take that petition was filed on 18th of October. The same day the Kerugoya file were filed. All the directions in all these files that have been taken to a graveyard is that none of these files of ours have orders. The reason as to why Kerugoya files before the learned judges is purely because they have orders to stop the swearing in of the deputy president-elect. The CJ could not have selectively decided to have only one file before you, my lords. This is a trial of the judiciary. It is a trial that goes to the root cause of whether there is impartiality. Yes, my lord.
Mr. Omari.
Yes, my lord.
The file you are addressing us, we have said, is not before us. And files which are before this court are the files in which this specific bench has been empaneled.
Thank you, my lord. Allow me to mourn. Because the questions I'm raising are very pertinent, that there are files selectively brought before you, but there are others.
Mr. Omari, we wouldn't know that because, as you understand, we only deal with matters in which we have been empaneled. We do not empanel ourselves.
Thank you very much. The empanelment authority has heard me loud and clear. Thank you, Judge.
And Lord, if you could mourn elsewhere.
I have indicated in this honorable court that there will be at least 3 clarifications.
Just a minute, Mr.
Yes,
I think we need to get something right. I want to clarify how these files are before this bench this morning. The 3 files which were filed in Kerugoya, that is 13, 14, and 15 of 2024, had some interim conservatory orders issued by the court. Further to the issuance of those orders, the learned judge made further orders requesting the Honorable Chief Justice to empanel a bench. Those files were transmitted on the basis of that order to the Honorable Chief Justice's office on the 18th of October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you are all aware that we are operating online. Applications were filed online. When those applications were filed online, those are the ones which this bench gave directions for these matters to appear before us today. That is why you are here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to this file, which we did not give directions for it to appear here today. So I think we can now proceed on the basis of that clarification.
Thank you, Judge.
Madam,
just a minute, please.
Perhaps just to add that the numerous other petitions that are coming up, I think the process is ongoing. Maybe not all the files have been transmitted to the bench. Maybe by the time we leave this courtroom, other files will have been transmitted to the bench. But as we speak now, here and now, these are the only files that were transmitted to the bench and in which there are applications where the bench gave directions for hearing today. That is not to say that those are all the petitions there are. We don't even know whether the transmission has been done yet and that we will go back and find all the other petitioners whose concerns are valid. Perhaps those files will now be before the bench formally.
Yes, Madam, I believe now I can be able to make the clarifications. We are starting with the immediate background that we need to make these clarifications and to take...
Let us finish with the quorum first. There's a quorum in E013, which was consolidated in Kerugoya with E014. Just take quorum on that file.
There is something wrong. And I believe it is important for us to put things into proper perspective. Because when you call the matters, if a team was not part of what was called, I've not had perhaps the call. Your Lordship, in E015, there has never been a consolidation. To the best of my knowledge.
Why are you talking about consolidation? Nobody has talked about any consolidation. These files have not been consolidated. I think that is the next process we would be going into. Nobody has talked about any consolidation. If you look at the record, you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated, and let us proceed from there. If you want to apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The directions from this court were very specific on 3 different files.
My lords, I'm well guided, but when Justice Rima was giving the clarification, I never heard him clarify whether the Kerugoya file has been integrated into the Nerota system. Because we cannot be then be dealing with a file that is reading Kerugoya. Because of course, if there is no integration, Your Lordship, then there is a rat that is made.
Let me answer him. He said that record speak for himself. And for record, matters which came from Kerugoya came with their own record. And the record states here that the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Kerugoya was already consolidated. Those proceedings which took place in Kerugoya consolidated these 2 files. So let that not be an issue here, please.
Issued on the 11th, it also confirms the same.
On the directions issued on 11th by Judge Richard Mwongo, these were the directions. The petitioner in E014 2024 to serve their amended petition on all parties. Similarly, the petitioner in E013 2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to Honorable Chief Justice forthwith, the parties' response to the amended petition and petition E013 of 2024 may be filed in Kerugoya under the Kerugoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Kerugoya. So this court has not consolidated any matter. Petition number E014, and petition number E013 are hereby consolidated. The parties who appeared before the Kerugoya court were given those orders. Those were your orders.
And with your permission, Presiding Judge, the reason why Nairobi has not opened another file to put together all the files from Kerugoya is this. Going by the orders which were issued by Kerugoya court, there was a specific order that because of the transmission, parties will still file their documents under the Kerugoya CTS, that is the contracting system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place.
I presume we will now raise the issues that we want to raise, particularly arising from the issue in Kerugoya. And
we will then proceed and take quorum on it. They were consolidated, so we will not take further quorum on this matter.
The Attorney General, I don't know, I have indicated to the court, I need some clarification.
Section 7 of the Attorney General's Act.
You had already asserted. Does it override my right to represent my client?
I'm repeating it.
Can she then say her piece? I say mine.
Which matter are we now dealing with?
We have 0115.
We have several.
We have 0115.
My Lord, I wanted to say that
Yes.
the only matters before this court are the matters which had ex parte orders. The matters that came from Kerugoya E13 and E14, although consolidated, they were filed before impeachment and they have no conservatory orders.
I think they
We have E15.
E15 has
conservatory orders, but E13 and E14, although from Kerugoya, they were filed before impeachment and they had no conservatory orders.
Yeah.
I hope that we have other appearances. My Lord, my Lord, I'm leading the number of applicants in this matter from Kenyaga. E015. 15. Yes, yes. Yes. My Lord, the clarification that I seek to raise emanates against this general background. The first one, my Lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client wrote a letter to the Honorable Chief Justice, which has been placed on record in an affidavit, in an application before you, that protesting, amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of government that have violated fundamental rights is a practice that is prohibited under the 2010 Constitution. That mechanism. We do not trust that the Honorable Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, Your Lordship, sir, that you are convened by the Honorable Lady Justice Will, the Deputy Chief Justice. My Lord, arising from that are one, a legal issue and a matter of Article 150. My Lord, under the law, and we do this every day, I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing, as required under Article 47 of the Constitution. We will be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday,
my Lord, may
I think I have a right to raise those issues.
Professor Mugai, just give the fellow Mugai time.
Mugai. I just wanted for good order.
Okay, is that the clarification, Mugai?
Mugai. I am Mugai. I believe he will speak in response as soon as I'm done.
Proceed.
My Lord, I wanted to assist the court because my learned friend has, I believe, filed a substantive application so that the court does not hear speeches in vacuo. My learned friend should identify what application he is ventilating so that even we taking notes know what we should be responding to. That's all I wanted to say.
Professor Boigai was a former Attorney General. I respect him. He was also my teacher, my professor of criminal law. But my Lord, the point that I wish to make is that I am acting for specific clients today, and that's before the court. I should be heard in silence. He will respond. And I dedicated that we have formal applications. What we are raising is an issue that is arising from what Judge Mulima has indicated. We could not put it earlier in an application. So if I may proceed, my Lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they would seek on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact, So then the first clarifications would be, on what basis would, in an application by the executive, be convened on a Saturday? That is a substantive issue because of the second reason that our background that we are giving. But under the 2010 constitutions, the constitutions provide for the Bill of Rights. My lords, under the former constitution, but under the former constitution, we used to have a practice in which we had unofficially a bill of immunities for the state, where the constitution, the state could conduct its business on weekends and outside court sitting hours. But because of that reason, that's why I'm saying, this, we are sitting here pursuant to the orders made on a Saturday. And my lord, we are also sitting here pursuant to an order made by the Honorable the Chief Justice. My lord, for purposes of Article 165, I believe it's 4, of the Constitution, the powers of the Chief Justice to appoint a bench is a substantive power. It is not administrative. This power, my lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. That our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165(4) of the Constitution. And we shall place here the Deputy Chief Justice a formal application. Issue number 2, my lords, arising from that.
You apply that we discharge the directions of empanelment.
But I am saying that we shall make a formal applications to discharge that order made by the Deputy Chief Justice. That's what we are indicating. Well, number 2, and it is implied in the applications for disqualifications that we have filed. Number 2 is that we raise the issue that for purposes of the Saturday sitting and today's sitting, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the orders that were made. My Lord, I have a lot of respect for all of you that have appeared before previously. But my Lord, pursuant to my instructions that that would be the case, 3 issues worries us. Number 1, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoys special privileges. Number 2, my Lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my Lord, and it is important that these issues speak for the wananchi and with a clear conscience. 2 things. My Lord, the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is issued to set aside the conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state as it used to happen those days before we had a new constitution? Issue number 2, my lords, is this, the issue of bias. And this is bias by the Honorable
I think, Mr. Mugai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you
Let me raise the other issue that
yes.
does not have to do with those things. But the last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my Lord, there are about 4 matters. One of them in which I appear. And this is a fundamental issue. That matter is coming on Thursday. Okay? An express order of the court that has not been set aside. The question would be this: for purposes of good order and for purposes of us making this application, why would it be difficult, even for this bench, to order all cases, because that is the right to equality under Article 27 of the Constitution, that deals with the same subject matter, come on a specific day where all parties have noticed, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But Lord, why I say, as I go to see, why I say this is important is this: the matters before you over and over again, the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So that, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application, is clearly not permissible.
Mr.
So that may not
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged her administrative duties the way it should be done. But if you have an issue with that, please don't make a generalized complaint.
Well, this is not generalized. It is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I sit down, the issue of that right is that we have had a situation before the National Assembly, before the Senate. It didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you respectfully.
We hear you.
My lords, just to add on what I submitted on.
Just a minute, please.
With the permission of the presiding, I wish to say that. I wish to make this clarification. The matters which are before us today, the 3 matters which are before us today, are not here on the basis that some conservatory orders were issued per se. I have stated and I'm repeating. The reason why these matters are before us today is that after the issuance of the conservatory orders, subsequent applications were filed. The applications were filed after the empanelment. Those applications were filed online. We deal with matters online. And it is on the basis of only the applications which were filed and dealt with online, that is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the applications which were filed, which came to our attention. So kindly let us be as factual as possible. We will deal with all the matters. I can assure you there is no issue about any of the things you are raising. If you have any substantive issue, we are here If the application for recusal, there is no problem. We will hear. If we feel we have to get out of this, there should be no problem. We are all here to defend the Constitution of Kenya. So don't you worry. Don't you worry. Give us time. Let's take this thing step by step, and we will do the best we can as a bench. Thank you.
Allow us to worry when we have crowds.
No problem.
Sila Council Mute and Council Ndegwa. You know, when you argue the way Mr. Mugwe has argued, that court sat on Saturday, you are arguing on both sides of the court. You know that we work online, and most of you know that matters reach us anytime, at any time, whether at night, and that is what the new constitution and the e-filing system has brought to this country. So when you argue selectively, you mislead the people. You mislead the people outside there that court sat on a Saturday. There's nothing like that. We attend to matters online as and when they come. But we have had Mr. Mugai. Let it not be an exchange between the court and yourselves, because we are really very neutral party. Let us hear also from the other side.
In E015 in Kiboko, the deputy president is the second respondent, first respondent in fact. We haven't seen the abuse, and Elisha Ogoya will be making submission to that. But Lord, do give us, these are very weighty matters. This E015 in Kiboko, the orders of your brother, Mr. Justice Mungu, were given at 4 p.m. When did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night on Friday? Permit us to articulate these issues for the sake of the nation. We're not just dealing with the removal and the challenge to the removal of the deputy president. We are dealing about the president that will be set for the removal of deputy presidents in future and the removal of presidents in future. Elisha.
My Lord Presiding Judge, I want to renew my request that the court permit us to be orderly. We are now about to hear a second speech, a third speech, a fourth speech. This court, as we have been told by the senior most advocate here, is a court of record. What application are we hearing so that we on this side can prepare to respond? We cannot respond to speeches. There is an application here, if I may, the Honorable P.K. Moite. There is an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. But having brought it, they should then confine themselves to it. Then we can respond to it. But we cannot sit here the whole afternoon listening to speech after speech intended for another audience other than this one.
Let us be clear on this. The applications before this court, we have stated which applications are in this court for hearing today. We have no authority to call any other file, because files, when there's a prayer for empanelment of a bench, those files go direct to the Honorable Chief Justice. So we have no authority to call any other file to ourselves. That will be quite unprocedural. So what we have here are the 3 files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing, we can deal with it and dispose of it one way or the other. But I don't think it's really necessary to have speeches in the absence of specific application and prayers.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, the advocates appearing for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, it necessitated us to address you, Your Lordships, on Article 165, Clause 4. On the constitutionality of the constitution of this bench to hear these three specific files. And that's the issue that we want to address even before we go to the application for release. Because it's our humble view, Your Lordship, that the so-called empowerment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, Clause 4, it is our reading that the only person who has the capacity to empanel a bench is the Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number two, Your Lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Why did the Chief Justice execute her functions and her mandate under Article 165 Clause 4? What was the necessity of the delegation of this function? Those are pertinent issues, Your Lordship, that requires clarification before we go to the roots of the matter, the crux of the matter. It's our submissions, Your Lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice. That's why the constitution is in white and black, that the obligations and the duty belongs to the Chief Justice. Finally, Your Lordship, the reason why we find ourselves in this situation is because of what the court is struggling to explain to us. That 3 files have graciously generated expediency, and other files that were consolidated, that 6 files with the lead file 522, have no reasons why they should be before you. Noting that, Your Lordship, those matters were equally satisfied as urgent and raising heavy constitutional matters. When I looked at your orders, Your Lordship, that you issued to summon us today, you repeated the same, that they raise weighty constitutional matters. Why are we being discriminated by the court that our files are not considered as a priority, and that the files with orders are the only ones that the court is sitting on a Saturday? The Chief Justice is empanelling, the Deputy Chief Justice is empanelling the bench. We are called, like in a lightning speed, to appear before you. Is it not because there are some orders that the state wants to vacate? You cannot run away from that reality, Your Lordship, most respectively.
My Lord, with your kind permission, for the record, Dr. Kamodo for the field respondent, he is to speak. I believe the reason we are here and the reason why we took forum is because we recognize that there are different parties to these proceedings. So it will be abominable for a section of the parties to seek to colonize these proceedings and treat them as if they are the only ones entitled to the audience of the court. So in this regard, my proposal is as follows, that each of the party whose representation has been taken gets an opportunity to indicate to the court what applications they have before the court, so that we are able to proceed methodically. And each party then, the court can then give directions on how we move to treat each of those applications. Otherwise, we may be here indefinitely if each of the parties takes the opportunity accorded to make lamentations, to make speeches, and to mourn. So we respectively urge that we get an opportunity for each of the parties to ventilate the issues, because the federal respondent has a pending application, which is being filed, a preliminary objection, which even contests the jurisdiction of the High Court to hear the matters, because it is a matter relating to the combination of a presidential
over Deputy President, which in our view lies squarely within the domain of the Supreme Court. So we, once accorded an opportunity procedurally, we shall ventilate all those issues, and hopefully the matters being raised or being raised about recusal and so on, they will fall by the wayside. Thank you, Madam.
For the fifth interest, for the first interested party.
Mr. Goya, just a minute. I was about to interject when when Council, Mr. not like the other one. Yes, Mr. Degwa was addressing, and that is exactly why I wanted us to have order in the way we conduct these proceedings. And I was about to ask Mr. Degwa, after all that, what is your application?
Your Lordship, I'm very clear in my application.
His application can only come after I have spoken.
We are now making an application. You respond.
Well, what is it that you want?
Your Lordship, permit me to make an application under the Mutunga rules that following the disclosure of the court this morning that was made by Justice Murima, that this honorable court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165, Clause 4 to empanel this bench. Your Lordship, this is the background of my application. That on the 14th of October 2024, the Honorable Chief Justice did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file being 522. And the files that were consolidated, Your Lordships, my lady, were 522, 509, 537, 528, 525, and 506. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Kerugoya, was equally slated for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing by this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you on the 16th of October, Your Lordship, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
My Lord, I'm sorry we are constrained to interject to seek your guidance. My name is Muzomi, appearing for Professor Kibiki. Listening to my colleagues, he is making an application before this bench, complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish
Na mtazamaji, ni kikao cha mahakama ambacho kinaendelea hapa Milimani jijini Nairobi, huku majaji ama jopo la majaji watatu waliochaguliwa na Jaji Mkuu Martha Koome kusikiliza kesi za kupinga kuondolewa afisini kwa naibu ama aliyekuwa naibu rais Rigathi Gachagua, ikiwa tayari